To err is human, but to learn from is divine. Hi, and welcome to the Law Simplified, the world's largest independent online law school platform. I'm your instructor, Shaveen Bandaranayake. Irrespective of the preparation that you've put in, the amount of hours that you've spent studying, or even your understanding of the law for that matter, your career trajectory, your success or failure in the fraternity, and while I don't want to put it in this context, the choice of progressing in law in general is determinant upon an assignment submission, a fact pattern or essay question that you answer in a timed assessment, or a dissertation for that matter, if you are in an LLM or a PhD program. As a result, your competence, your ability, and your confidence is meant to be communicated under the current premise of examinations and assignment submissions by way of what you put down on paper. Now, on every single occasion that I conduct fast-track tutorials and workshops for my students all around the world, one common denominator that I tend to impress upon everyone is not just how to articulate responses, but also how to learn from mistakes that you've made. Most students fail to recognize the genesis of the problem. What do I mean by this? When you write an answer, be it a fact pattern or an essay question, more often than not, what tends to happen is the feedback that you may receive, if you are fortunate enough to receive feedback from your university or your institution, is what exactly you've done wrong. And while that is quite helpful, particularly when it comes to assessments later on in your semester, you might not necessarily be able to put your finger on why exactly that happened in the first place. And the reason for that is because most students tend to address issues as they come, as opposed to proactively trying to reflect on why they took certain decisions during an examination or an assignment submission. Now, on a number of occasions on this very YouTube channel, as well as the different platforms the Law Simplified is disseminated on, I've tried to impress upon students why you should not simply put down on paper everything that you know on the one hand, or merely opinion on the other. Rather, it should be an amalgamation of the facts, the law, your understanding, and more importantly, your personality and your argument as to what you believe the outcome should be. Now, as you may be aware, while I may tell you this in abstract, you might not necessarily be able to comprehend in a practical context what I mean. As a result, this video is meant to give you a fundamental understanding of a question, a response, and a feedback report at that, and how you can utilize that feedback to not just correct those specific mistakes, but to learn from and even make your answer scripts much better. So first and foremost, let's have a look at one such example. Let's have a look at a feedback report that was prepared for one of my one-on-one masterclass students. These feedback reports are subsequent to the tutorial and workshops that we conduct, where I will break down an articulated response and then later give a question to the student to attempt based on the techniques that they've learned. So first and foremost, this particular feedback report is in relation to a question in the law of tort, specifically negligence. You can pause this video and have a read through the question so that you can have a brief understanding of what might be needed, what might be required. Okay, now that you've had a look at the question itself, what you need to understand is these feedback reports are broken into 4 particular parts: the good, the bad, technical, and analytical thinking. I'm going to focus on the bad area, and in particular in relation to something that the student had missed out on, where the student had simply mentioned a particular case and expected the examiner, in this case me, to understand that he or she knows what's relevant, when in fact there needed to be more discussion. So let's first have a look at what the student had spoken of, and then afterwards we'll go through the feedback and what learnings and what reflections we can have from it. Right, now having read the question, having read the scenario previously, you'd know that there is clearly an issue pertaining to breach. But specifically, having a look at the scenario, you know that there is fundamentally some uncertainty in relation to the drug that has been administered by the consultant, by the doctor. Now, as a result, one major component that needed to be discussed was the discourse between the impact or the application of the two seminal cases of Bolam and Bolito as it relates to the opinion of a professional, in this case a medical professional. Now, as you can see from the response of the student, there is an indication that Bolam is necessary. So for example, it says prior to this case, a doctor's duty to warn patients of risks was based on whether they had acted in line with the responsible body of medical opinion. This was known as the Bolam test. If the law is applied to this case, then Karen has conducted herself in an unprofessional standard and has breached her duty of care to Karen. Once again, apart from the fact that there are mistakes in terms of syntax and the application, because there's a reference to the doctor twice as opposed to the patient alone, there's also a missing component here, which is the distinction between Bolam and Bolito, which is the newer case. So what you'd gather from this is A, the student has failed to understand why exactly the Bolam test is used. B, failed to recognize that there's a newer case which talks about it slightly differently, which is Bolito. And finally, looking at the overall discourse, it's a fundamental issue that has not been addressed, because it's the opinion that would determine, or the reasonable or unreasonableness of the opinion that would determine whether there is a breach that has happened, and where there is a breach, that's potentially negligent from there onwards. So from this context, the bad that we see and that we can outline is that there is no context given for how Bolito is to be used in conjunction with Bolam, which the student has mentioned. So have a look at the bad component and specifically the particular feedback that's relevant to this. Now overall, whenever you decide to write an examination question, it's insufficient to simply state cases or state principles without knowing why it's relevant. The rationale behind certain types of applications is purely to make sure that you can substantiate your arguments. Most students tend to answer these questions at a relatively subpar level because they are looking at it superficially. They look at cases, they look at the principle, and they sometimes even by heart it without contextually not knowing why it's valid. Right. That was an example of an actual student response to a question from an examination, as well as the feedback that was associated with it. You'd notice that for the level that the student had actually engaged with the question, I might have seemed like I'm nitpicking. But the idea of doing a law degree is not simply to pass it, but to ace it altogether. Having taught students for the past 9 years and conducted hundreds of tutorials and workshops at different difficulty levels, ones which tend to go up the scale over time, it's fascinating how the issues that crop up among students, I mean, irrespective of the jurisdiction, being quite similar. There are certain patterns that emerge when we consider the ability for a student to look at the facts presented, develop arguments on their own, and present them in a manner not just understandable, because there are occasions in which a student's mind might be as muddled as what he puts down on paper, but also to set yourself apart from everyone else that the examiner is marking. Because after all, as I've mentioned in the past, your response is only as good as the response marked by the examiner before you. It is a subjective test after all, And no matter how much we try to quantify it and to look at it in a reasonably objective manner, there is a component of luck and there is a component of skill involved. The whole premise of preparing for an examination or an assignment submission in law is to make sure that you go above and beyond that which is expected from you as a student. If you'd like to learn more about how to not just break down questions but also articulate responses at a first class level, I'd highly recommend enrolling in the online law school platform, where you'll find tutorials and workshops where I've broken down questions and articulated responses with students who have gone on to achieve first class law degrees globally. But until the next time that we meet, have fun, stay safe, and as always, obey the law.